Committee on Housing and Homelessness Prevention to order. First up on the agenda is Senate File 558. That is a bill that I am the chief author of, but Senator Kroon is a co-author of. So I am going to move Senate File 558. And Senator Kroon, I will turn it over to you.
Thank you, Mr. Chair, members of the committee. Thank you for the opportunity to present Senate File 558. This is, I believe there is a author's amendment on this one.
There is an author's amendment, and it is the A2, and I will go ahead and move the A2. It is in your packets.
That's what I have.
And this is an amendment, the A2, to get the bill in the shape the author desires. Is there any discussion on the A2? Seeing none, all those in favor? Aye.
Aye.
All those opposed? And the A2 is adopted. Senator Kroon.
Thank you, Mr. Chair. This is a bill for the removal of unauthorized persons from real property. I guess it's otherwise known as the squatters bill, commonly. And, this is an issue that is popping up around the country. Here in Minnesota, it has popped up in certain areas. Think perhaps northern cabins, that are unattended for large periods of time. And there's some other landlord-tenant situations where it can arise. And so I'll briefly do a walk through the bill for you so you can understand what our proposal is here. And then Senator Utke, another co-author, is with me as well to talk about some issues that his sheriff, has had with this issue, and then we can open it up for questions. I guess in summary, what the bill does is it puts an orderly, lawful process in place to avoid confusion. So the sheriff has a guided process and makes it easier for the sheriff to make decisions in tough cases or cases where it isn't obvious the occupant is a trespasser. It gives the sheriff protection for following this process, which is a really important piece for our sheriff. So this brings predictability and consistency to how we deal with these kind of tough situations. So Section 1 of the bill, Mr. Chair, Subdivision 1 within Section 1 simply establishes the right to request the removal, and it has a number of conditions that must be met. Those are clearly stated forth. Subdivision 2 details the element of the complaint, and then Subdivision 3, or actually still in 2, provides a template, a form, an easy form that complies with the statute and sets forth the sheriff's verification requirements and the service of process requirements. So Subdivision 4 allows the sheriffs to charge a fee. Subdivision 3 is the one that provides, sets the sheriff's verification requirements, service of process requirements. It's the templates in Subdivision 2. Subdivision 4, again, allows the sheriffs to charge a fee. Subdivision 5 gives the sheriff immunity if he follows this process. Again, a very important point. Subdivision 6 is also really important. That is protections for the occupant for a wrongful removal. And Section 6 is the civil penalty or civil action, that is available to an occupant who has been wrongfully removed. That does provide for a lawsuit, that does allow for attorney's fees and treble damages, so a very significant penalty there. And then Subdivision 7 is an actual criminal penalty for a property owner or authorized agents of the property owner who submits a complaint or uses this process generally and gives false statements to a sheriff or other evidence to the sheriff, knowing that that statement or documentation is going to be relied on pursuant to this. So we really wanted to make sure that this doesn't get abused by any property owners, and so we put those two provisions in there. Subdivision 8, of course, is just to let people know that it doesn't limit any other right or remedy that the property owner or a peace officer might have in these situations. And then there's a use of excess force provision in there as well. And then if we go forward to Section 2 of the bill, this is an interesting, important part of the bill, where it provides clarification on holdover situations. An example that has been litigated would be a guest of a tenant who is unauthorized to be in the premises, and then the tenant abandons the premises, and what is the status of that guest? This clarifies that and says that they are an unlawful occupant and does not establish a tenant relationship. So that is a walk through the bill. And with that, I will turn it over to Senator Utke.
Thank you, Senator Kroon. And before I turn it over to Senator Utke, I just want to provide a little bit more commentary on this. Right now, in the state of Minnesota, there is obviously per civil law a tenant-landlord relationship that guides the use of property in a tenant-landlord relationship. And unfortunately, in the last several months or last year, we saw many headlines happening from around the country where people were breaking into other people's property in an unlawful manner and either manufacturing a tenant-landlord relationship or otherwise portraying themselves as somehow having a legal right. And what this bill is seeking to do is separate the genuine tenant-landlord relationship, which is established per contract, from those unlawful occupants that are trying to deprive rightful owners of their property and treat them more in the fashion of trespassing. It's trying to make that distinction because the process in a tenant-landlord relationship is a civil law process that goes through housing court for eviction. When trespassing and when there is not that tenant-landlord legal process, that's what this bill is trying to further provide guidance and remedy for. Senator Kroon.
Thank you, Mr. Chair. That's true, and really, it's as you said, if it's not clear and the property owner has to treat this person who has no lawful basis to be there as a tenant, it becomes a very lengthy and a very expensive process. So the goal of this bill would be to expedite that process while still having some structure around the process. We don't want to put sheriffs in difficult situations where they're making judgment calls on an ad hoc basis. You might have inconsistency around the state in various counties. And so we wanted to have a structure around it, but we didn't want to have it take forever and cost a whole lot of money. So that was kind of the balancing test that we were looking for in drafting this bill. And then from my perspective, personally, my involvement was to make sure that it complies with Minnesota law as well, and working with Senate Counsel, who was really helpful in putting this together to make sure that other elements that have been used in other states that were good ideas actually fit within the structure of existing Minnesota law. So it's very workable and could work in Minnesota if this were to become law. So that was really important as well, and I enjoyed that part of it.
Thank you, Senator Kroon, and I will turn it to Senator Utke.
Thank you, Mr. Chair. And I am going to share with you and the rest of the members here today the letter that started it all off for me, and that happens to be from the Hubbard County Sheriff, my county sheriff, Koriakis. And I'm just going to read the letter. So these are his words, and it shows how the challenges they had and the reason that the request for this bill is in place. So for the members, it says, I am reaching out looking for support in making a change to our eviction laws in the state of Minnesota. As the head of a law enforcement agency in Minnesota, I see the constant issues my staff deal with in regards to rental issues and squatters. Typically, when a landlord wishes to evict a tenant, they must first serve them with a 30-day eviction notice. For the typical landlord-tenant written lease agreements, I don't have an issue with that. But what law enforcement agencies across the state deal with time and time again are situations much different than that. We deal with people couch hopping or the subletting by an official tenant to friends or acquaintances without the landlord's knowledge. The problem is that once an individual has established residency, the owner must go through an official eviction process to get them out of their home or house. A lot of times, establishing residency was done without the landlord's knowledge. For example, a lawful tenant lets his girlfriend move in with him, then eventually break up and he moves out. Now, ex-girlfriend has no place to move to, so she decides to stay. The landlord then shows up to get the house ready to rent out again and finds it occupied. One might think the landlord can simply tell the person to leave, but under Minnesota law, an eviction is needed. And evictions are not just a 30-day process. It starts with a 30-day notice and then oftentimes grows into another 30-day notice and a court date. And after that, the judge can issue an order for the occupant to leave. If they refuse, the judge would then issue an order for the sheriff to remove the occupant. This simply isn't right, and why I'm asking for help. We simply need to make the eviction laws easier for landlords to take possession of their properties. Sincerely, Sheriff Koriakis. And again, I just notified Corey late yesterday, communicated with him last night. He would have loved to have been here. The timing just didn't work, so you were stuck with me for a fill-in. But this is what he's looking for to help in Hubbard County and across the state for law enforcement and the tenants, or the landlords. So thank you, Mr. Chair.
Thank you, Senator Udke. Now turning to the list of testifiers, I have first on my list, Sarah Bertsinger, if you would come forward. And it's my understanding that there are several people that also the timing did not fit to be able to come here in person, but that you have several stories to tell on their behalf. So
Correct.
Please identify with your record and proceed.
Good morning. Hello, my name is Sarah Bertsinger. I'm from Pine Island, Minnesota, and thank you for the opportunity to be here today and put a face to this legislation. So basically, I just want to start off with a number of stories from my area. To begin with, it will be Dawn. She's from Zumbrota, and she retired. She downsized and decided to rent out her home. She did for a couple years, and then she wanted to sell her home. The issue was the renters could not find a location, and they refused to leave. So after months of headache, thousands of dollars in court fees, or legal fees, she was finally able to get her house back and resolve with the situation. A similar friend in Rochester had a similar issue with someone who was a guest of the tenant who refused to leave. And unfortunately, in that situation, they destroyed all of the appliances on their way out. The next story is from a business owner in Pine Island. He is a young father of 4 young kids, and he rented out his facility to a restaurant. After a few months, the restaurant no longer paid the rental fees. However, he still had to pay his mortgage, he still had to pay property tax, and the restaurant continued with their business. It took almost a year to get the restaurant owner out of there, and when all is said and done, he was in the hole, this young father was in the hole about over hundreds of thousands of dollars. Where I come from, it's a very rural area with lots of farms and outbuildings, and my Aunt Lynn actually wrote a letter that she'd like me to read here today. To the chair and committee members, I'm a landowner of the farm off of the Lake Shady Avenue in Orinoco, Minnesota. I and other property owners have regular issues with trespassers, a number of whom have attempted to set up camp. I've needed to invest hundreds of dollars in cameras to set up various locations in an attempt to be notified when someone is trespassing. In the spring of 2024, I was away from the property when my camera notified me of 2 females, a male and a young female child, parked their car on one of my driveways, and they started lugging camping gear into my woods. A couple hours later, when I was able to return to my property, I drove to where they were parked to find out what was going on. I found the adults in their late 20s to early 30s passed out on a rug next to a camping gear that they had set up. Their 6-year-old female was playing with her doll on a rug. I nudged the female closest awake, which then woke up the man, who became very combative. The male became verbally and physically combative with me. I informed him that this wasn't a good idea and that I was asking him to leave, and informed him that I had called law enforcement. Because they were obviously intoxicated, I blocked their vehicle and told them they would need to have a friend to call who was sober to come and get them. This enraged the male even more. I retreated to my vehicle and was waiting for law enforcement when one of their friends came to give them a ride. The Olmsted County Sheriff Deputy showed up shortly thereafter. I told him that what had happened, and I intended to have their vehicle towed if it wasn't gone by the morning. Squatting and the intention to squat is a significant issue and has been for years in southeastern Minnesota. Much of it seems to be connected to the drug problem we have here in Olmsted County. Besides wooded property, barns, homes, grain bins, and sheds all are targets of squatters. I support any legislation that gives property owners the right to have squatters removed from their property, and the sooner the better. Sincerely, Lynn Koenig. So thank you for your time and encourage your support on this legislation.
Thank you, Ms. Bersinger. And next on the list of testifiers is Mr. Dahl with Homeline. If Mr. Dahl would like to come forward. And you can identify yourself for the record and proceed.
Thank you, Mr. Chair. Good afternoon. My name is Michael Dahl, and I am the Public Policy Director with Homeline. Homeline is a statewide tenant advocacy organization that provides legal advice, education, organizing, and advocacy services to Minnesota renters. Thank you for the opportunity to testify. Senate File 558 is a bill that's trying to solve a problem already covered by trespassing law. A landlord, like any other prime property owner, can call the police to arrest the trespasser under Minnesota Statute 609.605. Applicable portions of Subdivision 1 read, a person guilty is guilty of a misdemeanor if a person intentionally trespasses on the premises of another and without claim or right refuses to depart from the premises on demand or lawful process of the lawful possessor, or occupies or enters the dwelling or locked or posted building of another without claim of right or consent of the owner or the consent of someone who has the right to give consent, except in emergency situations. I should also note that the owner could also get a harassment restraining order to remove the person under Minnesota Statute 609.748 and 609.749. Again, the applicable sections read, a person commits harassment under this section if a person directly or indirectly or through third parties manifests a purpose to intent to injure the person, property, or rights by another commission or unlawful act. This would include trespass. Or if it returns the property to another, if the actor is without claim or right of property or consent or the authority of consent. The court can issue an order for the harasser to stay off the property. Beyond this, beyond the lack of need for this proposal, there's also significant due process problems with the bill. The bill allows the sheriff to remove a person from the property without a court hearing. The only way for the person to challenge the removal would be to file a case with no quick process for resolution, unlike eviction, lockout, rent escrow, tenant remedies, and the tenant remedies action. Lastly, additionally, for line 4.1, which defines unlawful occupants as someone that does not have written permission from a landlord to occupy the dwelling. This would potentially invalidate all oral leases in Minnesota, which are specifically allowed under Minnesota Statute 504B-001, Subdivision 8. The statute defines a lease. A lease means an oral or written agreement creating a tenancy in real property. So there's a real chance that this would give a tenant in an oral lease arrangements a way to sidestep all tenant landlord protections for possession of simply because there is no written permission allowing the tenant to reside in the property. Please vote no on this proposal, again, as there are already methods to remove the unlawful occupants from the property, and this proposal is not written in such a way that protects tenants under oral leases. Thank you.
Thank you, Mr. Dahl. I have no further testifiers that have signed up in advance. Is there any from the audience who would like to testify? Seeing none, members, is there any comment? Senator Bolden.
Thank you, Mr. Chair. I have a question, just a procedural question about the action that we will take on this bill. And for that matter, I'm going to have the same question about the remainder of the bill. So I don't know if you're going to take that one by one or all together. But what will we be doing with this bill today?
That is an excellent question, Senator Bolden. So on this bill, we're going to be laying it over for possible inclusion. The next bill, the Draheim bill, Senate File 222, will be laying over for possible inclusion. The third bill on the agenda, which is Senate File 559, will be, it's my intent to move that with recommendation for passage to the judiciary. And the fourth bill is an informational only, so there's no action. Any further? Oh, Senator Draheim.
I thought Senator Mohammed had her hand up, but you know, I think, thank you for presenting this bill, and I think, you know, as a landlord, I can say that again, after many years of not being a landlord. You know, most of us take very serious the kind of the quiet enjoyment of that property. So we are looking out for all the tenants in a building. And, you know, and I think my bill will get to this a little bit too, and I think this bill does quite a bit. The apartment that I rent up here when I'm in St. Paul has had problems with squatters. And it ruins the enjoyment and the expectation that the rest of the people have on the floor that these people happen to have been on. So, you know, I think it's a balancing act, and I think we're asked all the time to balance things out, and I think we can do both. I think we can give tenants rights, but yet there are more tenants than the alleged squatters, which I don't know how they would have tenant rights if they're not legally a tenant, but that's a whole nother issue. So I just think we need to keep this front and center this year when we try to balance that out. Because I have an email string, I'll call it, with all the tenants that I share my St. Paul apartment with. And that's their number one complaint, are people in the building that don't belong in the building. And there are young families in that building. So we have to work together to try to figure this out and find that balance of, you know, giving people all their due process that Mr. Dahl talked about, and yet still protecting the people that we are legally responsible as a landowner and a property owner to do. So I don't know if Senator Kroon has anything to add to that, to my comments, but I just want to remind the committee that I know this is an interesting topic when we get to tenant law and some of the things that we've talked about last year and this year. And I think we both can be right, but I think we have to just not say no and back into our camps like we have done in the past. So that's just my thoughts. Thanks.
Thank you, Senator Draheim.
Sure, I can.
Yes, Senator Kroon.
Thank you, Mr. Chair. Thank you, Senator Draheim. My comments on your comments is, yes, I do think it's a balancing act. You know, we do need to keep both landlord and tenant in mind, and I think, I practiced real estate law for a number of years. Evictions were not anywhere near the top of what I did, but I did do some of those actions from time to time, mostly on commercial property, but occasionally on residential property. And I could see the law trending more and more towards tenants and well-intended additions, to be sure. But what people don't often see is how difficult it can sometimes be for an ordinary landlord who maybe can't afford a lawyer or it's not cost effective. It almost never is cost effective to hire a lawyer, first of all, in an eviction proceeding. And, how long it can take and how frustrating it can be. And then those costs do get, added on in the form of rent. And so, and I would just say that most of the landlords I work with ultimately would, because the law was so difficult to navigate, you'd try to work something out and sometimes just pay the tenant to leave, which is not really what the law should encourage. That the law should be more user-friendly than that. But having said that, to the testifier's point before, I mean, yes, there are trespassing laws on the books. I'm well aware of the trespass statute, but that is not fully adequate to address some of these situations because it's not always easy to determine exactly who is and who is a trespasser, or putting the sheriff in that difficult position in that moment to make that determination. And so in those cases, this is a nice process, I think, for the sheriffs to have that is structured and does provide, some procedure that's for the landowner to go through and for the sheriff to be able to rely on. So, that's number one. And then as far as the concern about how this is wiping out oral leases, I would just say that in, line 4.11, to be an unlawful occupant, the person residing in the dwelling cannot be a party to a lease with the landlord. So that is a defined term over case law, and so that's kind of the threshold. Then it adds those other two on. So I don't think it eliminates anything like that, but it does eliminate the person who has not established a landlord-tenant situation, who is occupying the dwelling, not subject to a lease, but is saying, I have permission, otherwise permission to be here. This is saying, no, that permission needs to be in writing for that to fly. So that is the distinction there. So I just wanted to make that clear. We did think through this to make it consistent with existing Minnesota landlord-tenant law, with the changes being specifically what our intent was.
Thank you, Senator Kroon. And I just want to emphasize, and I appreciate Mr. Dahl and other testifiers, the need to protect due process and the need to recognize where there is an established tenant-landlord relationship by contract, oral or written. And we have a civil process for that. We have the courts. But at the same time, we also need to recognize there are bad actors out there that will attempt to abuse the process, abuse expectations, and they will go into somebody's property. And there are multiple stories of people being on vacation for extended periods of time, or maybe traveling to a different state to take care of a family member who might be sick, and then returning to find somebody in their property unlawfully and having to go or treat them as a tenant when they are manufacturing a false relationship and an expectation that it's going to take weeks or sometimes months and thousands or tens of thousands of dollars to regain their rightful property rights. That's what we're trying to create a separate process for, is for those actors who are unlawfully denying and depriving somebody of their rightful property. So with that, Senator Port.
Thank you, Chair. I'll be quick. I think I agree with much of what has been said, that there is trespassing laws and the fact that testifiers referred to these folks as trespassers, and it seems very clear in many of these situations that what we have is trespassing. If law enforcement the sheriff in that case isn't able to do their job to remove those folks for some reason and doesn't have the resources to do that, that is a different discussion, and we should have that discussion in judiciary. And, you know, I think that is one piece of it, but I am interested in the one through line in all of these stories is that, you know, when someone wouldn't leave, it was because they couldn't find another place to go. And I think that is the core of why we're having this discussion in housing today. It's not about the judiciary laws because we don't have jurisdiction over that. It is about the fact that there are people across Minnesota who cannot find a place to live. And that is something we should take very seriously in this committee. It is not an acceptable thing for anyone to go into a property that is not theirs. But it is also, to me, unacceptable that there are Minnesota families who are living without shelter and that we have not provided the resources across our state in many communities. In fact, many, many times we have underfunded Greater Minnesota in this way to make sure that there is affordable, available housing for people to live in. I am not a lawyer. You're welcome to that job, Senator Kroon. But I think, you know, that the judiciary conversation is one y'all should have in judiciary. And, like, please do. But I think critically, like, one of the things we have to be discussing is how are we providing shelter for folks who are unhoused? How are we providing affordable and deeply affordable housing across Minnesota in all of these communities? So it is not just resources that are available in the metro or resources that are available in community hubs, but really that impact every single community across the state. To me, that's the core of this issue. At the base of this is people who don't have homes. And so for that reason, I appreciate you bringing this forward because I do think there's shared common ground here that we can find and talk about ways to move forward. And I will leave the judiciary details to you.
Thank you, Senator Port. Senator Mohammed.
Thank you, Mr. Chair. I have a few questions. And you sort of mentioned, and I think Senator Draheim actually mentioned, no, it was Senator Lucero who mentioned it, and said that, you know, often there are folks who will go on vacation and leave their home and their property, and then they'll come back months later, and they'll come back to an individual who will pretend to be a tenant and occupy their space. What legal protections does that actually have under any of our statutes?
Senator Kroon.
Thank you, Mr. Chair. The issue is not whether or not that's legal to do that. I mean, the issue is how does the sheriff address that situation? And each case is obviously going to be different. The purpose of this, I think most people would agree, a squatter, as we commonly think of it, you could think of as a trespasser, but it's really it's establishing a process to deal with it in an organized, structured way that also preserves rights on both sides and make sure that we're doing it right. And sometimes it will be obvious to the sheriff, and they won't even need to go through this situation because it's obviously they're a trespasser and they would deal with them as they would with any other trespassers. Sometimes it's obvious they have established a tenant relationship, and then you will have to go through the eviction process. I kind of view this as kind of a middle ground for some of those cases where a tenant relationship hasn't been established, but the sheriff would like to have this process in place to have a safe harbor, if you will. So if we go through this process, you know, the property owner and the sheriff know they're doing it lawfully, know they're doing it the right way, and you know, the public knows that there's a process out there as well. So that was the intent of it, not simply to say that what people who go into somebody's homes without permission are somehow legal at this point. That's not what the intent of the statute or the bill.
Follow?
Senator Mohammed.
Thank you. I think we're on the same page that unlawfully staying in another individual's property is illegal in the state of Minnesota under statute 609.605. So I'm glad we've been able to establish that at least. Now that we know it's illegal, would you say, Senator Kuhn, that we have an enforcement issue?
Senator Kroon.
You could say it's an enforcement issue. You could say, thank Mr. Chair, Senator Mohammed, thanks for the question. You could say we do have an enforcement issue. You can also say that this law does provide guidance under the law in situations that could be currently considered ambiguous. I think it's an and situation rather than an either or situation.
Senator Mohammed.
Okay. Okay. Maybe you can go a little bit into how it's ambiguous in terms of the statute, like where it says that there are scenarios where an individual who has no legal rights to a property can be considered a tenant.
Senator Kroon.
Thank you, Mr. Chair. Thank you, Senator Mohammed. Again, these are case-by-case situations. Every situation is going to be different. The person that there is going to maybe say different things to the sheriff. When the sheriff comes, they might have different documents. They might have forged documents. They could say, this or that. I mean, each situation is difficult, or different, so it's difficult to kind of paint with a broad brush on what those situations are. I mean, there could be a myriad of them. And again, maybe how this is dealt with currently, maybe the sheriff just says, I'm going to view them as a trespasser and remove them. But this is actually an enhanced version to provide some structure so the sheriff has this process to go forward. So, I'm not sure if that answers your question, but that's kind of my thought on that.
Senator Mohammed.
Thank you. I'm almost done, I promise. And then I have a question that Senator Lucero has asked me over the years, which is what stakeholders have you worked with when you came up with this language?
Senator Kroon.
Thank you, Mr. Chair. Thank you, Senator Mohammed. This isn't my bill. I'm a co-author on this bill. So primarily what I have worked with Senator Uckey and his sheriff as he testified to. My primary focus on this, once Senator Lucero brought it to me, was to make sure that it fit within Minnesota's statutory scheme. And so that the how it would operate would be consistent with our other portions of statute. So I really enjoyed working with Senate counsel and going line by line and changing this here, taking this out, saying, no, this doesn't apply to Minnesota. That's a different state situation. That's been my focus. You'd have to ask Senator Lucero kind of the broader question on who he's worked with in terms of why he brought this bill and how he did it.
Thank you, Senator Kroon. And Senator Mohammed, so the background on this is as one of the things that I've been doing as a legislator now for 11 years with the privilege of this body is trying not to be reactive, but doing everything I can on different policy areas to try to be proactive. And one of the things that I saw last year in 24, and it might have even been in 23 as well, is some of the goings on as Senator Port has referenced. There's been a housing crisis and a housing issue, not just in Minnesota, but it's been across the country. And some of the symptoms are, as what we're describing here, that it has been seen and witnessed in other states, and there is testimony, and others have reached out to me that it's occurring in Minnesota here. And so the stakeholders that I've been working with and communicating with have been private property owners. Another scenario that we haven't, wasn't brought up, but that is very real, and it's a threat, is when a property is listed for sale, not for rent, but it's a private property owner who wants to sell their property. It gets communicated far and wide, online and in other arenas, that a property is more likely than not vacant. There is an opportunity then for those bad actors to break into that property. And so that's everybody in the real estate world whether they be agents, brokers, or private property owners, sellers. But then another scenario is landlords who list their property on various websites that they may include the address, they'll include pictures of the inside and the outside, so that there are bad actors out there scouring websites trying to find property that's vacant, it's a prime target to break into, and then forge documentation that they then have some kind of legal reason to be there. So that's who I've been working with, private property owners, individuals who reached out to me, and then again, my own self with an interest in this arena.
Thank you.
Senator Mohammed.
Thank you, Mr. Chair. And then I have one last question, and then I promise a thought, and then I'm done. In the bill, page 3, subdivision 4, there's a language on there that says when such a request is made, the sheriff may charge a reasonable hourly rate, and the person requesting the sheriff to stand by and keep the peace is responsible for paying the reasonable hourly rate set by the sheriff. And my question for you is, what about small landlords, if this became a law, who don't have funds to pay sheriffs an hour or a certain amount of money for them to stick around, for them to feel safe?
Senator Kroon.
Thank you, Mr. Chair. Thank you, Senator Mohammed. That language was borrowed from existing eviction statutes. I mean, basically, the sheriff's role, I mean, to back up, most evictions don't go all the way through the process where the sheriff shows up at the premises and says, you're out of here. Those are rare situations, in part because the process is so long and arduous. But in that situation, the sheriff's role is to keep the peace. It's not necessarily to go and physically remove the person that is there. So now it could come to that if the peace is not kept, but that language has been around forever and is borrowed. And I do want to correct something I said earlier in response to one of your previous questions. When you said, isn't it already illegal? I took that question to mean kind of the traditional squatter thing that we primarily have been talking about here. But there is the other part of the statute in section 2 that would take what the courts have considered to establish a tenant relationship and make that person an unlawful occupant. So that would be a substantive change. So I just wanted to clear up my answer on the trespass question because it is a little bit more nuanced than I had previously said.
Senator Mohammed.
Thank you. I appreciate you for answering my questions. Senator Lucero, I'd love to keep working with you if you're going to keep working on this issue because, I care a lot about tenant protections. But we've had this discussion last year for a bit in judiciary when I presented the tenant protections package bill. And under statute 609.605, which in my opinion is pretty clear, criminal trespassing is already illegal in the state of Minnesota. And I think what you may be referring to is that we may have some enforcement issues. And if that needs to be cleared up, I'd love to work with you on that. Thank you.
Thank you, Senator Mohammed. Next on my list is Senator Abler.
There you go. I appreciate the discussion. Sorry I was late. Just a procedural question, more like it seems to me, you're going to lay this over. However, I'm not going to mess with what agreements you've made with whomever, but it seems like a lot of the people on both sides of the aisle have an interest in this, and it should be in judiciary at some time, which I'm pleased not to be serving on, nor will I go to help the bill either way. But I think if you're just a suggestion, and you can act on it today or next time, but if truly you're interested in seeing if there's some way to make this work to solve a problem, which I don't experience in my district, but I've heard anecdotes around, and so it's good to get after it. I think it's got a meritorious intent. And so just to suggest if you were interested to send it to judiciary, perhaps without recommendation, and then bring it back here if it ever survives that. I want to encourage people in the committee and in the audience, the future of this project will at some point wind up in the hands of the House Judiciary Committee, which will at one point convene, and that'll be Representative Scott and Liebling. And so I see that as a pretty thoughtful group, and I don't see Representative Liebling in particular whizzing something through that is undesirable to the people that have some of the concerns. So that's just my suggestion to you as you want to think about it. I'd be happy to vote for any motion like that. Thank you.
Thank you, Senator Abler. And when I was in the other body, I had the privilege of serving both on the Civil Law Committee and on the Public Safety Committee. They split them in the House. And in the Senate here, it is combined as the Judiciary Committee. Double the fun. You don't know what you're missing for not serving on the Judiciary Committee. But I agree. The intent is not to have partisan or a bitter differences in this. It is to try to work together. And I continue the conversations with Senator Port, and we are going to lay it over today, but I do agree. It should go to judiciary because this is within the jurisdiction. The reason it's in housing is because obviously this touches a housing aspect. And as we continue these conversations, it is my hope that we can move it to judiciary and leave its fate in their hands. Next on my list is Senator Bolden.
Thank you, Mr. Chair. I will be fairly brief because Senator Mohammed actually asked one of the questions I was going to ask, which was around stakeholders. And so, I think that is an important part of the process and would encourage you as you continue to work on this to engage with, tenant advocacy organizations and law enforcement and all of the folks who are, potentially connected to this. I think it was Senator Draheim who mentioned balance, which I think is important. This strikes me a little bit as tipping the balance too far away from due process and rights for tenants, and we want to, be sure that we get that right. As we are hearing, stories today, third hand or further removed about, the problem this is aiming to solve, it strikes me that in many cases it's looking to just move the eviction process faster, or, is around really what is trespassing, which has been discussed. There are strong criminal trespassing laws in place. And so important to, be sure that we are careful about that balance and engaging those folks who have a stake in this. And I also just want to thank Chair Port for your comments around, what is relevant here in the Housing Committee, and really what that through line is that there we have folks who do not have a place to live, and we are seeing rates specifically among family homelessness and senior homelessness rise. I believe seniors are the fastest growing rate of homelessness in our state. And so none of us at this table want that. And so I look forward to the conversations to continue in this committee of ways that we can solve that problem and address that together. So thank you.
Thank you, Senator Bolden. Next on my list is Senator Draheim.
Thank you, and thank you, Senator Bolden, for your comments. And it sounds like we have a couple more topics for some hearings coming up. Chairs, maybe a homeless update would be great. And I would also put a push in for the bill I have next to you. Maybe a senior update would be great too. But back to procedure for today is why I raised my hand. And then maybe this is council question. But are we laying this on the table, or are we laying this for possible inclusion? Because and if we do either one of them, can we still move it to judiciary? That would be my question.
Thank you, Senator Draheim. I had initially made the motion to lay it over, but I think you are correct. So I'm actually going to withdraw that motion to lay over. I'm going to move the motion, or I'm going to move that we recommend Senate File 558 for passage and send it to judiciary. And so that will be the motion before us for now, as amended. So Senate File 558 as amended.
Can we take a recess, please?
Yes. With that, members, we will recess. Do you have any further comments?
Thank you, Mr. Chair. Thank you, members of the committee. It's my first time in housing. It's been a good, interesting conversation. I appreciate the questions. Although I'm not the chief author of this bill, I don't know if I can say this, but I'm absolutely willing to work bipartisan with anybody who has an interest. Even, obviously with you, Senator Lucero as the chief author, but if I can be of assistance to help make this bill better, and I'm absolutely willing to do that.
Thank you, Senator Kroon. And in our brief recess, the co-chair and I were discussing Masons in the order of motions. And so the proper order is to withdraw my motion and instead to make a motion to just have Senate File 558 as amended laid on the table. And with that, members, all those in favor say aye. Aye. Nay. Senate File 558 as amended is laid on the table. Thank you so much, Senator Kroon and members. Next, members, on our agenda is Senate File 222, and Senator Draheim, as he approaches the table, I will allow him to make the motion, and you may proceed when you're ready.
Thank you, chairs. Great discussion on the last bill, and I'm sure we'll have equal discussion on this bill. So I would like to move Senate File 222, and I believe that this will be the same as the previous one, delayed on the table. So.
That is correct, Senator Draheim.
Okay.
Senate File 222 is moved, and you may proceed.
Thank you, members, and this is a jacket of an amendment that we did last year and had a bunch of discussion on. So I don't think this is new to the members of the committee that were here last year. And a lot of work was done on tenant law last year. And I want to thank Senator Mohammed for her hard work on that area last year. And like I said before, I think there needs to be balance on what we do here. And I understand the intent of the community organizer being allowed into the building. I just look out for the remainder of the tenants. Besides the one tenant or multiple tenants that want to organize and feel it's necessary. They should have the right to do that if that's what they want to do. But as a property manager or an owner of a building, we are responsible for everybody in that building, not just whoever many want to organize. And I think this is a happy balance with this, that we're just going to ask for a background check on who we're letting into our building. And, when I woke up very early this morning, one of the first stories that came on the news was about how, I think it was 5 young people went to a basketball game up in Fridley and beat a guy with a piece of iron, I think on the bench, that was actually playing basketball. Walked into a school and beat a 17-year-old. And awful. Nobody wants that. And, and this is in a public school in Fridley. My sister lives in Fridley. My nephew and niece went to Fridley. I've probably been in that gym. So, yes, that's a little more open than an apartment. But we have young kids running around in these apartments. We need to protect them also. So we need to find a balance between protecting everybody in the building and still let them organize. I think this is a common sense approach. I think Senator Pa and I were discussing earlier that she thinks there's probably a tweak that might help the bill get better, and hopefully she'll bring that up. But it's pretty straightforward, members. I just think that we should ask for a background check for whoever we're bringing in to the building. Now, I don't want cost to be an issue. And if Senator Paul wants to talk on that, I'll let her go, otherwise I'll keep on rambling. But we were discussing about how we think that could be abused. And, you know, a bad actor, meaning a property manager or landlord, could inflate the cost of what a background check costs, or find the most expensive possible background check out there to make it cost prohibitive. And I don't think that's right either. So Senator Paul talked about putting a cap on that background check. So it isn't $600 or $500 or $400 or $200. It's more cost effective. So that was kind of the discussion we had. I would love to get the committee's thought on that and Senator Paul's thought.
Thank you, Senator Draheim. And before we go to testifiers, it looks like Senator Pa would like to speak.
Thank you, Chair. And I want to say thank you to Senator Draheim for bringing this bill forward. I do support this bill, and the reason why is because, again, it's non-resident when we're talking about this. We're not talking about residents who live in these complexes that are organizing. We're not limiting that. But if you're a non-resident of that apartment or that unit, there should be some type of background check that's done for the safety of the people who are living there. Again, I spoke with Senator Draheim about making sure that there is a cap on this so that, again, it isn't abused by certain landlords to, as a way to not allow organizers in the building so that they can do some tenant organizing. So maybe suggesting to Senator Draheim that a max be put on here of, let's say, $50 as a background check cost, equal to or actual cost up to $50. That way, we are protecting the people who are current tenants of these multi-family housing units, and we're making sure that we're giving people access to organize. The reason why I support this is, again, these are non-resident organizers. We're not putting this stipulation on actual tenants who are already living in those units.
Thank you, Senator Pa. And it's the chair's intent that this bill will similarly be tabled. So we have an option here. We could either make an oral amendment before we table it, or we also have the option to table it without making any oral amendments and then continuing that conversation. So what would is there an interest in?
To me, if I think it's a reasonable train of thought to go down that we could see this being abused. And I think if it makes the bill better, you know, obviously it has another stop and it'll be up to Chair Port to decide where and what happens here with this. But I think to get it in the shape, I think it makes it better. I would like to have an oral amendment of what Senator Pa discussed.
Okay, so who is making that oral amendment, Senator Draheim or Senator Pa?
I'd be happy to. Thank you, Senator Draheim, and thank you, Chair. And maybe legal counsel can kind of help me make sure that we have it in the right format here. But I was thinking about in line 1.13, to the landlord in an amount equal to the actual cost to the landlord at a max of $50 for conducting the criminal history background check.
Thank you, Senator Pa. And counsel, when you can, if you would read the oral amendment.
Mr. Chair and members, this would be page 1, line 13, after the second landlord insert for a maximum of $50.
Thank you, counsel. That looks good. So is there any discussion on the oral amendment? With that being said, all those in favor, say aye.
Aye.
Aye. No? The oral amendment is adopted. We now have Senate File 222 as amended before us, and Senator Port had raised her hand.
Thank you, Mr. Chair. Thank you, Senator Draheim. Just want to flag a few things before we get into deeper conversation. As we brought this bill, as this bill was brought up last year and the tenant organizer bill was put into place in the first place, we did require that these folks be accompanied by a resident of the building, which I would like to point out we do for no other person entering a building. There are plumbers, there are cable people, there are installers for all sorts of things. There are anyone a resident invites in. There are delivery people. There are hundreds of people who can enter an apartment building without a background check. And there is no reason to believe that tenant organizers are any more likely than any one of them to commit a crime. This is a targeted, very, very specifically targeted bill that will have the effect, whether it's the intent or not, will have a chilling effect on allowing residents to organize. If this were really about safety, it would be about requiring background checks for anyone who is a non-resident to enter an apartment building, or at least anyone who is working, coming to do a job in the building to be required a background check. But we don't do that. And there's been no mention of that in the 3 years that we have discussed this bill. So I guess I don't understand what's changed from the last 2 years, but this is, to me, a pretty blatant attempt to chill tenant organizing. And I don't mean that that is an attack on you, Senator Draheim, but I think it's what the bill does. And I don't believe that there's any documentation at all that supports that tenant organizers are in any way a risk to the community.
So if I could respond, Chair?
Thank you, Senator Port. One thing I will just add is, on that note, I've worked for a number of employers over the years, and I don't think I've ever worked for an employer that doesn't do a background check as part of their hiring process. So when it comes to the cable person or the FedEx or whoever other employees of the companies might be, there likely is a background check of some kind. At least there's an accountability. And many times when they are showing up in that regard, they have some kind of identification badge many times. But there is a difference between that and I think this scenario. So just adding that as part of this is very fruitful.
If I can just respond, Mr.
Yes,
Chair.
please.
When we had tenant organizers here last year, that is exactly what they said about tenant organizers as well, that all of the tenant organizations in Minnesota do background checks already, and that often small organizations will bring those folks in so they won't be the ones who have paid for the background check and would be charged again to do a background check. They wear identification. They are employees just like anyone else is an employee. There is no reason to expect that these folks are anything other than doing their jobs, which is what we hope they are doing and what we have fought very hard, Senator Mohammed fought very hard to ensure that residents are able to organize to protect their rights in the same way that employees are allowed to organize to protect their rights, in the same ways that landlords group together and have lobbyists who come here and advocate for those rights. Tenants should have those same opportunities.
I was unaware that there was an industry that has employees of organizing that they undergo these checks. But again, it's shocking to me that there's an industry that is out there in the business of organizing in this capacity. But Senator Draheim has his hand up.
Yep, thank you, and thanks for the comments, Senator Port. I guess a couple differences on a community organizer and a repair person. The repair person would be picked by the property manager or the landlord, who is ultimately responsible for the building and the safety of everybody in the building. So it falls onto them. And on the community organizer, I didn't know they did background checks. And maybe we can amend the oral agreement that if there is a background check that's been done in so many months, that could be sent to the property manager or landlord without having to pay for another one. I'm okay with that. I'm not trying to block community organizers. I'm just trying to balance out, that I want to know who's coming in to the building. That's it. That's all I want. And so if we need to do another amendment to put that you can, if there is groups that do background checks and they can send a background check, that should suffice, in my opinion, within, I don't know if it's 6 months or 12 months or whatever, or for the calendar year, whatever works. I'd be happy to work with you on that. If that is the obstacle you think that's going to stop community organizers to come in, you know, I think we can find a balance there. So there's one background check, and that would work for the whole year. You know, I think I'm okay with that. So I think there is a workaround on that. But the main difference between a repair guy, so when, in most cases, all the repair people are coming from, and at the dollar of the property manager or the landlord. They pay the bills in most cases. Once in a while, washer, dryer would be about the only exception. And they pick who they want to work with, in most cases. So I think that's the differential. So I hope that answered your concerns.
Thank you, Senator Draheim. And our oral amendment led into member discussion. So I'm actually going to pause this, and I am going to go to the testifiers. So we do have 45 minutes remaining in the committee, and we still have 2 additional bills on the agenda. So with that, I would like to call forward Mr. Dahl from Homeline. If you want to come forward and give your name for the record and proceed with your testimony. And as he's coming up, Mr. Rivera Reyes is on deck from Equity in Place. Mr. Dahl.
Good afternoon, committee members and co-chairs. Thank you for the opportunity to testify. My name is Michael Dahl, and I'm the Public Policy Director for Homeline. Homeline is a statewide tenant advocacy organization that provides legal advice, education, organizing, and advocacy services to renters. Thank you for the opportunity to testify, and we appreciate Senator Draheim's concern for the safety and security of Minnesota renters. Unfortunately, the scope of File 222 will cause significant confusion and difficulties for landlords, tenants, and their guests. Residential renters in Minnesota, just like Minnesota homeowners, expect to have the right to allow guests to visit them. Guests of tenants, such as friends, family members, neighbors, or even a non-tenant tenant organizer, are all already covered by existing case law. In State versus Hoyt in 1981, the Minnesota Supreme Court clearly adopted the rule that a tenant has a right to give guests a license to visit, and the landlord has no right to deny or interfere with that license. Background checks are not required. Additionally, Minnesota legislature has further protected the right of political candidates and their volunteers to enter and canvass apartment complexes. This according to Minnesota Statute 211B.20. This law also does not require background checks. Senate File 222 requires a background check requirement for a specific subset of individuals who already would be subject to laws and lease provisions regulating conduct of guests. Expanding the background check requirement to other individuals like tenant organizers who do not have access or keys to the units is a slippery slope and could end up being so expansive that it could cause hardship for everyone. Should each and every individual guest that enters an apartment complex be subject to the background check by the landlord, regardless of the fact that they don't have keys for a unit? This would include family and friends of the tenant, personal care attendants, Meals on Wheels delivery people, agents of the or employees of the landlord who do not have keys, like janitorial staff, plumbers, caretakers. Senator Port and I were doing a little mind meld, I think, here before I got up to testify. It could also include city and state inspectors, prospective tenants, Amazon delivery drivers, and, as I said, political candidates and their campaign volunteers. Please do not support this proposal, which will not keep Minnesota tenants safer, but will instead create confusion within rental housing. If this committee is interested in supporting safety and security of Minnesota renters, Homeline is very happy to help provide suggestions based on experiences of our clients. Thank you.
Thank you, Mr. Dahl, and please leave your mind melds with Senator Port. It would be scary if you did a mind meld with me. You would probably not like what you found. Senator Draheim.
So just a couple quick comments, and I always appreciate Mr. Dahl's efforts in helping tenants. But guests of tenants are for that tenant. The difference in almost every case that he mentioned, like Meals on Wheels, would be someone is expecting them to come and knock on their door, not up and down every door other than the politician who is allowed in, if they have a pre-planned visit and a time, then they are allowed to come in. So that would be the only exception, would be us, which is scary. But all the other examples are to the tenants and their guests of that one tenant, not the whole building. That is the differential. That is the difference. So I'm open for ideas, but I really didn't hear anything there that convinced me, you know, that we would be veering off of what we discussed earlier about infringing on everybody else in the building. So.
The next testifier I have on the list is Mr. Rivera Reyes. If you want to come forward, identify yourself, and please proceed.
Hello, Chair Lucero, members of the committee. My name is Juan Luis Rivera Reyes. I'm a coalition organizer at the Alliance for Metropolitan Stability and the coalition organizer for the Equity in Place Coalition. Equity in Place is a coalition of 20+ primarily BIPOC-led nonprofits working in the state and in our region to come together to fight for housing justice in our state. I'm here to speak against the proposed provisions of Senate File 222. I would like to highlight that tenants are facing the harsh realities of what the lack of affordable housing is doing to our communities. Current tenants' landlord law protects tenants' right to organize and to invite non-residential organizers to assist them. Non-resident tenant organizers are required by state law, as mentioned before, to be invited by and accompanied by a resident as an invited guest. This legislation would hamper organizers due to the financial implications required in this bill. I also would like to highlight that this legislation would also create an unfair barrier for renters organizing in multifamily housing, as they do not face the same barriers as renters in single-family or in manufactured homes. Thank you for your time and your consideration. Happy to answer any questions.
Thank you, Mr. Rivera Reyes. Is there any other members of the audience that would like to testify? Seeing none, we'll move to member discussion, and I have Senator Putnam on my list. Senator Putnam.
Oh, thank you, Mr. Chair. Just briefly to kind of underscore the point made by Mr. Dahl and actually ask a question of Senator Draheim. So Senator Abler and I have been over here comparing our own criminal records. And the question that I'm thinking about is a little bit is this definition of what an organizer would be. It seems to me if this bill would move forward, it needs a much more precise definition of what organizer would be. Because while politicians may have a right to be in certain spaces doing political activity, not as residents, not invited, they're volunteers. Again, there's rules around where they have to be on the same floor with us and all those different kinds of things. But I think that would be one thing that would be important. And in terms of the larger argument for the bill, that's in terms of its composition. In terms of the larger argument for the bill, I think it would be interesting to hear a greater indictment of the status quo as a policy argument, as our friend Aristotle tells us. You have to indict the status quo. So what is the scope and scale of this problem? Do we have tons and tons of organizers out there who are committing all sorts of felonious, horrible things? And are there more of them doing that than would be harmed by the chilling effect of not having anyone there at all? So I guess there's sort of two parts to that. One is an encouragement to, as you work on the bill, kind of refine the notion of organizer. And the second is if you have a way of establishing the scope of the problem, either in terms of its intensity or its frequency. Does that make sense?
Senator Draheim.
Thank you, Chair, and thank you, Senator Putnam. Always love your comments. You know, the bill passed last year. Senator Mohammed, do you know the enactment date? Chair, if I could ask.
Senator Draheim, I'm hearing January of 26, 25.
So, Senator Putnam, it's brand new, the new tenant law bill that Senator Mohammed worked hard on. That's brand new. And this is something I brought up last year that I think needed tweaking to her bill. And kind of the why, if you will, we have a crime problem. And I know your community has also had some issues too. And we're having a hard time keeping property managers that want to be there, that want to help their tenants. And, you know, I get reports all the time of cars being stolen from the employees that work in the property management area, being assaulted. You know, I think we had more than one death last year from people coming in. So most buildings are trying to do everything they can to make the property more secure for its tenants. And that's the balancing act that I'm trying to work on, is how do we keep everybody in that building safe and secure? And that's why I just want to know who's coming in. And I think Senator Pau's amendment helps keep that cost to a bare minimum. And Chair Port's recommendation that if they're already getting a background check, can they fax it or scan it or whatever? I'd be okay with that. I just think we need a little due diligence to make sure we protect everybody in there, including the workers who work in the building. And, you know, it's, I think a common sense approach where I don't want to stop it, you know, I don't think that's the answer. And I like the fact that there has to be someone with them to go through, you know, I think that's fantastic. But you're also infringing on everybody else in the building by going and knocking on them. You know, I keep odd hours. I'm a workaholic. When I'm at my apartment, you know, sometimes I'm getting there very late or very early for others. There's a lot of people coming and going because they have shift work. You know, our medical staff or manufacturing staff at different positions have odd hours. And and if you have kids, you know how challenging it is to get sleep, especially working shift work. So I just think there's a lot there, and I think we have to just remember everybody. So that's kind of what I'm trying to do. I appreciate the comments, and I hope I answered your question.
Brief follow-up, if I may, Mr. Chair?
Senator Putnam.
No, I totally respect you a ton, consider you a pal, and I think that your intent on this is absolutely pristine. And I also acknowledge that it is a huge problem in my community. It's a problem in my apartment down here in St. Paul. My car's been ripped off twice because someone has walked in through the door to the parking garage. It happens. But I need more evidence that the person who did that was a political organizer. Do you see what I'm saying? I totally get where you're coming from, but I need a little bit more of that to make the argument more compelling to me. But I totally see where you're coming from, and I think
And if I could, Chair.
So one moment, Senator Draheim. Yeah. So it is the chair's intent to hopefully get this wrapped up in the next 4 minutes. So we've got 3 members on my list here. We still have 2 additional bills. So I just friendly reminder to everybody. Senator Draheim.
I was just going to say it's a tenant organizers. It's not a political organizer. So there is a difference. So that I just wanted to correct it. So.
With that, next on my list is Senator Pau.
Thank you, Chair Lucero. Got a question here, and maybe Senator Draheim or even legal counsel could answer this question. I was just reading my notes here, and I guess I might have forgotten that it may be clarity on, is it all non-residential tenant organizers must be escorted or accompanied by a current tenant while in the building? Is that they have to be escorted by a resident or a tenant of the building at all times, or do they just have to be authorized to be in the building to do the organizing? Get some clarity so I understand.
Senate Counsel.
Mr. Chair and members, Ms. Primo is here to answer some of these questions, and so I'd like to call her up to respond to that.
Ms. Primo.
Mr. Chair and members, the current law provision can be found at 504B.212, and subdivision 1, paragraph E states that a tenant organizer who is not a residential tenant of the landlord must be accompanied in the residential building by a tenant who resides in the building. So presumably that would apply at any time that that non-resident tenant organizer is present in that building. There's no other provision in the statute that that modifies that.
Senator Pa.
Thank you, Chair. That answers, I think for the most part, my question, just because I was unclear about whether or not it would just be authorized or if they're actually going to be accompanied by these, by organizers. My intent really is to make sure that we are talking about tenant safety for everyone. I'm not opposed to tenant organizing or tenant organizers. But I just want to bring up that not every tenant organizer is from an actual nonprofit or organization. It can be anybody that someone brings in. And as someone who just cares about my own constituents and all people, is to make sure that if we are bringing people in, that we're making sure that others also feel safe. Not saying that, again, no ill intent, but the thing is, I just want to point out that not every tenant organizer is part of an organization that has been somehow screened or part of a group. And so I'm happy to hear that at least that if there is someone who is authorized to be there that's not a tenant, that they are being escorted or accompanied by a current tenant, because that does make it safer for people. My biggest thing is that I've heard from my own tenants in my district where they just have random people knocking on their door. You often don't know who those people are. And so it's nice that when it's from maybe another tenant that lives in your building is also with them, so you know, okay, I know this person, even if I don't know this person. And that if they are authorized to be in the building, that they really are authorized to be in the building. And so those are my concerns. I still do support this bill. I think that there could be some workarounds we can do, or some things we can do to strengthen the bill, maybe to make it better. But my overall intent, and I know that Senator Draheim's intent, is really just for the safety of all of people who will live in multi-family housing units.
Thank you, Senator Pa. Senator Mohammed is next on my list.
Thank you, Chair Lucero, and thank you, Senator Draheim, for bringing this. I think we had a conversation about this last year, and I know your intent behind it, and I know it's an important one, and I really appreciate you for bringing it forward. For me, when we discussed this bill, the first session, we actually didn't pass it because we needed more time to go through the bill. And in the second session, when we did pass it, we took the amendment that folks are talking about right now, which requires for the organizer to have an individual who lives in the building occupy them. And that amendment, I believe, it came from Minnesota Multifamily Housing. And I think one of our Republican members introduced it. And so when we talk about the bill that we passed last year, and I think about why we passed it, I'll tell you a quick story. I was earlier this year in January, when it was really cold, I was in Hopkins with a friend of mine at her home, which was freezing, and she was renting. And every single person who lives in that apartment has no heater on, and it is up to the management to turn it on. And so when we think about tenants and their living conditions, they're talking to each other and they know what's happening, and often they've been scared to go and talk to management. And for us to allow them the right to organize, to talk to each other, to use a common space, for them to talk to professionals who do this so that they understand what their legal protections are, is really important. It's and ultimately it's what, this is a business, and it's important that we keep it afloat because we need these homes, but the business can't survive without the people, and the people can't die and they can't be living in conditions that are not survivable, that they aren't able to survive. And so the intent behind it was for people to be able to organize and to also have the opportunity to talk to management and have somebody in between them who actually goes through a criminal background check. These folks do go through that, and the organizations who do that work can speak to how they do that. And so, I know why you're doing it. I really appreciate you for bringing it forward, but I still don't agree with it. So thank you.
Closing remarks, Senator Draheim.
No, I'll save it. I thank you, everybody, for the discussion. I hope we will continue to work on this. I think it is something we need to flesh out. So thank you.
Senator Draheim renews his motion. Well, I will make the motion to lay Senate File 222 as amended on the table. With that, all in favor say aye.
Aye.
All opposed? Senate File 222 as amended is laid on the table. And Senator Draheim, I am going to pass the gavel to you and go to the testifier table.
I hope so. I didn't think mine would take that. Are you? Senator Lucero, would you like to move your bill?
I will. Members, Mr. Chair, members, I will move Senate File 559, recommended to pass and move to judiciary.
Go ahead, Senator Lucero.
Thank you, Mr. Chair, members.
I'm sorry, do you have an author's amendment?
There is.
Would you like to move your A2?
I would, Mr. Chair. I will move the A2.
Members, we have a author's amendment, the A2. All in favor of the A2 amendment, say aye.
Aye.
Aye. Opposed? To your A2 amendment.
Thank you, Mr. Chair and members. This was something I thought of over the interim. And so as we know, there is a very black stain on Minnesota's history in regards to restrictive covenants, racial covenants, that would prohibit certain demographics from being able to purchase homes. And those covenants are recorded on titles of property. Decades ago, such covenants were deemed illegal. But when it comes to real estate title and recordings, even though something is deemed illegal, it still exists on title. And there are good groups out there that are working to identify where such racial or restrictive covenant exists on title, and then work to record a document to remove such covenants from title. The idea that I had in the interim is when an effort is performed to remove those, it's still a document that has to be recorded on title. Recordings take place at the county, and each county has a different charge for recording documents. It's in the neighborhood of $40 to $60. And the idea that I had was if somebody wants to remove a racial or restrictive covenant from title, they should not be charged a recording fee. So, Mr. Chair, members, what this bill does is to prohibit a recording fee from being charged by the county for the recording of a document to remove such a restrictive or racial covenant. With that, Mr. Chair, I will stand for questions.
Thank you, Senator Lucero, for bringing the bill forward. I think Senator Port would like to go first.
Thank you, Senator Lucero. I signed on to this bill as a co-author. I appreciate you bringing it forward. I think it makes a lot of sense. I support this bill and support it moving to judiciary.
Senator Housley.
Thank you, Mr. Chair, and Senator Lucero, thank you. I too support this bill. I'm a co-author. I'm just wondering, and I should have asked you this earlier, but do you know how many properties there are that this might affect, that they would be going into their county and then just removing that wording?
Senator Lucero.
Thank you, Mr. Chair and Senator Housley. I do not know the answer to that. But it's going to, the closer you get to the metro, I think in our state's history, it likely is going to impact Ramsey and Hennepin County more, or maybe the 7-county metro area. But I do not know the answer offhand. That's why there are groups out there that are working to try to identify such groups. I suspect it's in the number of several thousand.
Mr. Chair, follow up. I guess property owners could probably just go look at their own title and save those groups a lot of work and just go do that themselves. Thank you.
I think council has a number for you. Ms. Beener?
Mr. Chair and members, according to Mapping Prejudice, which is a project at the University of Minnesota, there's 33,000 racial covenants that they have found so far, just in the Twin Cities.
Thank you very much. Yeah, much needed. Any other questions, comments, members?
Mr. Chair, let's see, there is nobody signed up to testify as far as I'm aware, but I would draw members' attention. There is a letter of support from legal aid in our packets.
Thank you, Senator Lucero. Any questions or comments on the letter from legal aid? And that letter looks like it's in support of your bill, so thank you for bringing that up. Chair Port, is there anything else you want to add, or should we? And this is getting laid over or moved to judiciary. So, Senator Lucero, would you like to renew your motion to move Senate File 559 as amended to judiciary?
I do renew my motion, Mr. Chair. Thank you. Thank you to Senator Port. Thank you to Senator Housley. Thank you, members, because this is an important issue. And it is one that I'm pleased and appreciate the support as we work to try to rectify the best we can the history on titles. So with that, I encourage support. Thank you, Mr. Chair.
So all in favor of, we need to make a motion on that? Okay. So, I'm sorry, Lucero. Yeah. All in favor of the Lucero motion?
Aye.
Aye.
Opposed? Motion carries. Thank you, Senator Lucero. Sorry, I was reading as I was trying to do chair work. Wasn't expecting that. Sorry about that. So next up, members, we have Senate File 536, Senator Lucero's bill. Also, go ahead, Senator Lucero.
Thank you, Mr. Chair. And Senate File 536, I'm not going to move it because this is an informational only. The reason it's an informational only is we don't have this in our committee's jurisdiction. It's currently in the taxes jurisdiction. And I'm not a member of taxes, so I wouldn't be able to necessarily, I don't have the same pull in the taxes committee, but I am hoping that there may be an opportunity in the future in taxes to discuss this. But what I wanted to do in our continued discussions, and this is one of the things that I'm so appreciative of this committee, as we have had discussions for years now, and we continue those, in trying to make the cost of home ownership cheaper, more affordable, and to increase the supply that is lacking in the state of Minnesota of homes. And there is no single variable that is driving the cost of construction, driving the cost of home ownership higher. It is a series of smaller and separate items that together are driving the cost higher. And so what this bill is seeking to do is deal with one of those. And it's dealing with the sales tax on the building materials for new construction. It's seeking to exempt the sales tax from said building materials. The inflationary pressures that we've seen have driven the cost of timber, the cost of sheetrock, the cost of all that is involved, the wiring, the electrical wiring, copper, driven those costs higher and higher. And as the sales tax is applied to those building materials, it has driven it higher. So if you would think, in a new construction house, you'll have 100, I'll say approximate, $100,000 to $200,000 in just the materials alone. That sales tax is currently being paid. If it's $100,000, I'll just use roughly 7%, that's $7,000. In $200,000 of building material, that's $14,000 that's being paid in sales tax. Now, when building a new house, the sum of all the costs, the cost of acquisition of the land, infrastructure installation in the land, the survey, developing the site plans, developing the architecture diagram, all of the individual subcontractors that are involved in the construction. So when leading up to the certificate of occupancy and then able to sell that house, it's the sum of all the costs that go into it, plus a margin for return on investment that then makes up the sales price. And it is $7,000, $14,000 or something closely. That is a significant cost as people are struggling to come up with a down payment to purchase a home. And then if you take that $7,000 or $14,000 in my scenario, and somebody were to get a 30-year loan, they are paying interest then on that, and it continues to drive up the cost even further over time. So again, what my goal is, and what I'm trying to do, is work on just one of the areas that continue to drive up the price. And if we were to bring this and make this law, that'll bring a little bit of relief in one of the areas. And I'll, again, do a great deal of striving towards increasing the supply, incentivizing the supply, and allowing more people to have more affordable homes. And with that, Mr. Chair, I do understand there's at least one testifier.
Thank you, Senator Lucero. I think Mr. Foster from Housing First. Please state your name for the record.
Good afternoon, Chair Draheim, Chair Port, members. For the record, my name is Mark Foster, Vice President of Legislative and Political Affairs for Housing First Minnesota. We're a trade group of nearly 1,000 members of the home building industry that have one goal in mind: advancing home ownership opportunities for all Minnesotans. Our members build the American dream across the state, building thousands of homes each year. While we understand this is a discussion for informational only purposes, we'd like to thank Senator Lucero for this outside the box type thinking as we address our housing supply and affordability issues across the state. Home buyers are getting squeezed, and it truly is an all hands on deck moment for housing. I asked one of my builders about the potential cost savings this language could create for home buyers, and they're largely similar to Senator Lucero's scenario there. So he ran the numbers based off a current model home that he's working on, a 1,600 square foot Rambler with a finished basement. And so currently sales tax is currently collected on lumber, windows, shingles, cabinets, millwork, appliances, lighting, sheetrock, and a few more smaller items. So with all of this in mind, the potential cost savings with the removal of sales tax would run roughly around $9,000 to $10,000 for this 1,600 square foot Rambler. And while $10,000 may not seem like a lot of money, please keep in mind that for every $1,000 in cost savings, roughly 2,500 more Minnesota families can afford that mortgage. So a reduction of $10,000 would mean 25,000 more families would have a shot at home ownership. So we know that money is tight around here at the moment, but an initiative like this would help showcase how the state is prepared to do everything and anything it can to help address our housing needs. So thank you for the opportunity to testify.
Thank you, Mr. Foster. Okay, we got multiple hands at the same time. Senator Mohammed's first. Thank you.
Thank you, Mr. Chair. Thank you, Senator Lucero, for bringing forward this bill. I think when we think about building more housing, at the center of it is the fact that we have our most, where we have the most shortage, in my opinion, is affordable housing. And so in your proposal, if we did this per se, and there's all these savings that are gonna come from this, what will go back to the potential homeowners instead of this being a gift to developers?
So if, Senator Lucero, if I could just interject just for a second, just for conversation's sake, I took 150,000. So I think I'm probably on the average home right now, it's probably real close to that in materials. And if you would get a normal mortgage and carry that over 30 years and amortize it for 30 years, and at current interest rate, which I put in at 6.875 for 30 years. So besides principal or with principal and interest, that total payment would be $354,000 over that 30 years. So you, as a homeowner, would be saving that dollar. So I know part of your conversation is about who can afford to build a new home. But if I can buy a new home for less, I'm able to sell my house for less. And then maybe that person who's buying the middle house can buy that for a little less. And then that starter home will be less expensive. But if I need to get an extra 150,000 or 100,000 for my house, you know what I mean? I'm gonna have to make that up downstream, and I probably won't sell it. Does that make sense? Senator Lucero, would you like to help clarify what I said?
Yes, thank you, Mr. Chair. So let me use a scenario, and I appreciate that. As you were talking, I have a mortgage, as a real estate agent, I have a mortgage calculator at my fingertips on my phone here. So what I did in scenario one, I ran a home at $400,000 at 6.875 for 30 years, and the monthly payment is $2,627. Then, if it took to just reduce it to $380,000, because there in the scenario that Mr. Foster brought up, I wasn't even thinking the appliances, which is 100%. There's appliances, there's the kitchen cabinets, there's other things that I wasn't factoring in. So I'm thinking I just subtracted by $20,000. So I'm comparing $400,000. And now if there was a savings of exempting the sales tax, so $380,000, so $20,000 less. $380,000, same 30-year mortgage amortization, 6.875, and it's coming at $24.96. So if I do the math real quick, $24.96 minus $26.27, that's $131 per month. Multiply it by 12 times 30, that's $47,000 over the life of a loan. Let's say somebody only keeps their loan for half that time. It's not quite as simple as cutting it in half, but nevertheless, what would that be, $24,ish thousand is a significant amount of money. And so that's the savings for the homeowner. But then in addition to that, the home building industry is very competitive, just like every other industry. They're very competitive. And when there's a reduction in the cost, it is reflected in the by reducing the cost, the sales price. And so in a competitive market, the home builders who are paying less are going to pass those savings on due to the natural forces of competition to pass the savings on to the sales price. So there's two savings in that answer, is my point, Mr. Chair and Senator Mohammed.
Thank you. Senator Mohammed, did you have a follow-up?
Maybe I would just say, thank you, that's helpful, but I think I would say that if there was guaranteed that this was going to the homeowner, then yeah, but in theory, sure, but there is no guarantee. If we were saying developers were gonna build housing at 60, 40, 30% AMI, then they can get the savings and eventually it'll go back to the individual, sure, but I don't see a guarantee in that in the long run.
Thank you, Senator Mohammed. I will just add that in my area, I would say 3/4 of the homes that are built by the home owner or the property owner. So they would have direct savings. I think up here in the metro, you have more of the bigger players that come in and build by the block, if you will, and that would be a little different. But in where I'm at, I think most people that do build hire their own contractor to build, because we don't have, I think only one of my communities, and it really isn't even in my district, it's just right next to it, has what I would call a big builder that builds by the block instead of the individual home. So in my area, what Senator Lucero said would be 100% true, because most builders build for the property owner and go from there. But I have a long list here, so if I could. Senator Powell, you're next.
And
then Senator
before,
Ford.
Mr. Chair, if I
Yeah,
may,
of course.
very briefly, it also that you're spot on in the conversations I'm sure all of us have been having is that the national home builders are not operating in rural parts of Minnesota. And I've heard from the cities who they just can't get the national home builders there. So they're working with other creative and innovative ways to perform construction, and it's much smaller builders, or it could be individual owners building much smaller projects. But that cost savings will immediately impact and be positive for those homes. But then again, in my mortgage scenario, that is guaranteed 100% savings to the person paying the mortgage, because they're paying a mortgage on a reduced amount, and they have an immediate savings month over month for the duration of that loan. Thank you, Mr. Chair.
Senator Powell.
Thank you, Chair. So actually, my question was right along the lines of what Senator Mohammed was talking about, which is, that's great that we can do the tax exemption, but how do we ensure that the savings are being passed to the consumer if it's being developed by a developer, or homes are being developed by big developers and being sold off? Oftentimes, they come up with more expenses that they say that covers, and those savings are never realized by the home buyers on the other end. So my big thing is, I love what you're trying to accomplish, but how do we ensure that home buyers are actually going to see the savings? And I wonder if that may be better as a tax credit to people who are to Senator Draheim's point, is people who are just looking to build their own home, and they hire out a contractor or developer to build that. Then I can see that they would then be able to save on some of that building materials. But if they're buying a home that's already been developed and developers are not passing that savings along, that's just pretty much could be profit that they realize for themselves and never passed on. And not only that, but how many of our homes now are being built that are also really expensive luxury homes that would also be realizing these benefits? Wouldn't it be better that we target more affordable home development, starter homes, under a certain amount? And then, so like one, targeting. Two is, could it be better to do as a tax credit to regular people who want to build their own homes? That way we know that the credit's going directly to Minnesotans instead of to developers who we may never even see $1 of savings.
Thank you, Senator Powell. Senator Lucero, do you have a comment? Or
I do. Nope.
I have three other speakers.
Yes, so I think it's a great idea, and one idea that I'm thinking just off the top of my head, as a real estate agent or former real estate agent, we're familiar with the disclosure statement. The disclosure statement is generally 8.5 by 14 sheet of paper because it line items all debits and credits. And what we could do, again, just thinking off the cuff here, in the scenario of a new construction, we could require that the builder just add a line item on the disclosure statement that says, here is the amount of tax that is being subtracted from the sales price. So then the builder would compute what that sales tax was in the building materials that they had purchased. They add that on there so it can be seen by the buyer how much the sales price is reduced. And then therein, it is a guaranteed method of passing that on. In the scenario of the tax credit, I'm not super receptive to that, because what could happen is you would have a higher loan amount, and then you have your amortization and your monthly payment scheduled, set. And then even if you got a lump sum, let's say $15,000 credit, you're still now paying an interest rate and in your monthly mortgage payment for the duration of that life. So it's going to erode at what your savings would have been. So I'd rather try to avoid the sales tax figure from being included in the mortgage amount. And that's just off the cuff, that's what I'm thinking as a complication with the credit option.
Thank you. Senator Port.
Thank you, Chair. Thank you, Senator Lucero, for bringing this idea to us, if we couldn't bring the bill to us. I look forward to watching your hearing in Senator Rust's committee. I do think that there are some interesting questions here And as Mr. Foster said, all ideas should be on the table. I would be interested in, targeting this on maybe new homes under a certain number of square feet or a certain, percentage of AMI, things like that, so that we are targeting towards the kind of homes that we really know need to be built and that are affordable for Minnesotans to purchase. The natural forces of competition sometimes work, but right now they're super tilted toward the sellers. And so there is, no specific thing that would require the savings to be passed on from developers. And then the final question I have is just what would the fiscal impact of this be to the state? I think we would need to see a fiscal note and see what we're talking about, and if we would need to target it more specifically or have it be the first X amount of dollars, some sort of thing to make sure that it makes sense for the state as a whole. But certainly I think we should always be talking about how we can build more homes. And I will absolutely tune in to watch you take this bill to the tax committee.
Senator Bolden, do you want a quick statement? Okay, you're good. Okay, anybody else? Jim, you good?
Oh, since you dragged me into it, and I got 30 seconds. We're a little tight of money these days. I don't know if there's a way to conjure that this would somehow pay for itself through a public purpose that's important to us. But it's a time to be creative about how we do things that are really important. This may be one of the best things to do, particularly if we take the idea about putting it toward a targeted home style that we want to make more of. So just be creative about that. And I think there is money for things that are crucially important. I've been persuaded in my short tenure here that affordable, actually cheap housing is, home ownership is really important. So thank you.
Yep, thank you. Senator Lucero, Senator Housing is going to pass. So this is informational hearing. Any final words before I turn it over to Senator Port? She wanted to wrap up.
Sure. Thank you, Mr. Chair. Thank you, Senator Port. Thank you for members. Yeah, I very much appreciate and I love what Senator Port said. Everything should be on the table. And, as drafted, I just throw things on the table and let's talk about it. I don't have any illusions that whether it's this bill or another bill, that it's in its, the best way it can be, the best form it can be in. And so that's why I appreciate the feedback. Let's see what we can do, because I think it's a phenomenal idea, not just because it's mine, but because it's one that actually can have a real significant impact on not only people purchasing, but also to increase the supply, as we definitely know that we need in Minnesota. So thank you, Mr. Chair.
Thank you, Senator Lucero. Thank you, members, for your participation today. On Tuesday, we will be continuing our discussion on sort of the state of housing across the housing continuum, and we will have the agency here as well to go over the governor's budget. And Mr. Olofsson will go through our sort of budget overview that we have here in our committee. But with that, all business in front of us is completed and the committee is adjourned.